காலத்துக்கு ஏறாது அவ்வளோதான் தெரியும்.
So first of all, I welcome our great chief guest, advocate, general advocate. So he is in very busy schedule. So even in his busy schedule, when we contacted him, he readily accepted. So first I say my grateful thanks to our chief guest. So even yesterday, he sent some notes regarding the idea how to pattern artists' intellectual property rights. Okay, he sent some notes to deliver to you all. So from this, I can understand his interest on this topic. Okay, he is a lawyer, advocate, but he is very much interested on the idea. And also he is very much interested to talk among you students. So to motivate the students. You are all first year and second year students, some final year students also. I hope some final year students are present here. So final year students, already you have done some product. So you have to make it as a pattern. So this is the right time. You can learn. You can improve your knowledge how to pattern your product. So you keenly listen this lecture. This will be very, very useful. Also the first year and second year students, this is the right time. So even in your final year, you have to do many projects. So your project work you have to make a pattern. So now you can clear your doubt. How to pattern your work, how to pattern your product. Okay, you can discuss with our staff. Everything he will explain. So this will be very, very useful at the time of your final year. Today, from yesterday onwards, many of your senior students, final year students, they are presenting their project work. Okay, just now I made a review of their works. Okay, so many students have found many new ideas, many inventions. Novel ideas, they are presenting novel ideas. So I hope many students can pattern their ideas. Okay, so for this lecture will be very, very useful. So that we organize this program. So I welcome you all, our faculty members, our HOD Dr. Vadivel sir, Ravi Singh sir, and Dr. Jagar. Especially I thank Dr. Jagar. Okay, he only made the reason to call up this chief guest, Mr. Yusuf sir. Thank you, sir. I welcome our scholar and my dear students, faculty members. Also, I thank our management, director, madam, and principal sir. I welcome you all. You all enjoy the lesson. Okay, at the later you interact with the sir and make use of the lecture. This is okay. The purpose of the program is that only. Okay, IPR is a new term. Intellectual property. Okay, just you listen and interact, make use of the program. Thank you very much. Now I request Dr. Vadivel to present the memento to our chief. I wish to give a brief introduction about chief guest work, artistic lead, his present role. Okay, all of you must know. He is interested to discuss among the students being a advocate. Okay, so you understand what is his talent to grow. Okay, Mr. Yusuf was founded Whitefield Law Studio, a budding law firm catering medium-sized business His firm specially handles business recovery cases, consumer cases, rent control issues, motor vehicle. Apart from basic skill of drafting, reading, and conveying, he has tested experience in the field of arbitration, conciliation, being on intern at Council for National and International Arbitration, and that means Forum of Institutional Arbitration, and also currently he is a panel advocate of Bajaj Alliance General Insurance Group and also Equitas, a small finance bank. He is a go-getter and dreams to special legal awareness to the public. He is giving legal awareness to the public. Thank you very much, sir.
Good morning, everyone.
Good morning, sir.
இந்த லெக்சரா ட்ரீட் பண்ணலாமா இல்லை ஒரு கைண்ட் ஆஃப் தானே பேசிட்டு போயிடும் இது ஃபர்ஸ்ட் கொஸ்டின் கேஷுவலாக இருக்கலாம்ல ஃபர்ஸ்ட் கொஸ்டின் ரெண்டாவது கொஸ்டின் நானே பேசுவோம் நீங்கள் பேசுவீங்க இதெல்லாம் சார் எல்லாம் சொல்றது So, thank you very much for introducing me. Small session. I would also say that I am much more passionate about IPR, intellectual property rights, and I love to teach students. And even during my college days, I used to help a lot of my juniors to like about what I have learned and what is my experience. So I have founded a small law firm called as YQ Law Studio. YQ is again my name, Yusuf. So here it's a first graduate, like this is my firm. I try to entertain all the first graduates who have who for the first time are graduates in law. So let us start with today's session. Like you come so far from the city. Everyone would be living in the city. You come so far, so what is your motivation? Everything like why do you come so early in the morning? Like you know, come to the college, you wake up at 5:30, 6 o'clock. What is your motivation to come and sit here today? Attendance. Nice. Very practical answer. Attendance. Any more answers? Why is attendance? Okay, I will tell you. Why is attendance important?
80%. Excuse me.
I would say attendance is important so that you can write examination, you can get a degree at the end of 3 years. If I am not 3 years, 4 years, whatever it is. So that is why attendance is important. That is why people will give you marks and you are going to become a graduate. And why do you want to become a graduate again? Is the louder is
To earn money, sir.
correct. Nowadays, if you don't have a degree, you no one will give you money, right? So this is your motivation, right? So I would say today, since most of you are from first and second year graduates, I would say for researchers, for engineers, and for science graduate students, intellectual property right should be your motivation, and I would prove today that IPR is your motivation, right? Intellectual property rights again is a motivation to many researchers and innovators, and at the end of the session, you would say that yes, this is my motivation. So basically, let us not see that. I would deliver. What is IPR as per you? What do you like denote the term IPR? It's called as intellectual property right. Is it something related to mind? Intellectual right now? Is it something related to mind? What do you think of it? Maybe your professors would have told you intellectual property rights, research, patent. Sir has told about patent, but what is intellectual property right? Why it has come into play? Why this is necessary? All this is really important. We need to understand why intellectual property right actually first came into play. So can anybody over here tell me what is intellectual property right? So basically, intellectual property right is something which you cannot see, but it is very important for you. It is kind of a kind of a motivation or a protection given to people to further innovate. For example, if sir was telling that third year students are like showing their inventions today. What if I say you have worked hard for 2 years, you have taken your teacher's help, and all of a sudden when you go to apply a patent and somebody says I cannot give you a patent because already somebody else has applied a patent and he has got exclusive right over that patent for 20 years. I am sorry my dear, I cannot give you a patent. You have worked hard for 2 years, you never knew what is a patent. When you enter the third year, your sir says compulsory you have to give me a project, you have to give me a product. For that you are working hard for 12 hours every day, and at the end of the third year somebody comes and says I cannot give you a patent my dear because already somebody else has taken a patent, so how will you feel? So that is why intellectual property right is very important for businesses, industry, students, researchers and scientists. It will give you protection for a certain period of time so that nobody can copy your innovation, ideas, businesses, logos, everything. So there are certain forms of IPR. IPR, so what is exactly IPR? I would say, like in India, the most commonly known as IPRs, intellectual property rights, are first is patent. If you are a researcher, if you are a scientist, if you are an innovator, if you produce something, if you produce a process, if you produce a goods, which is, I would explain what is the patent in my presentation. Then in India, the patent office constituted by the government will give you 20 years license. Nobody can use your idea, your process for which a patent grant has been given for the next 20 years unless you give them the license to use. Right? So isn't this a motivation for you? Okay, I have invested so much of money, I have studied, I have got a degree, I have worked hard for an innovation, I have worked hard for a product which I have innovated, and I have got 20 years of license. There is just one small snippet. This one person called as, if I am not wrong, Mr. Sandhu. One person has got 1,140 patents alone in his name. So maybe he has got 1,140, and I feel he's the only person in India with his own name. Okay, and tomorrow one of you may also get 1,140 patents in your name. Anybody can do that something. So the point here is just a fun fact that how patent is really important and how you should be seriously thinking about patents right from today. Right. So next is just a very brief available IPR in India. The next is the copyright. If you is an author, if you are a photographer, if you are an artist, right? So getting a copyright will is a trademark. Everyone would know. Who knows Apple? Who knows iPhone over here? iPhone. Everybody knows about the half-eaten apple. If I show you a half-eaten apple, can you say which company is it? Which company is it? Apple Inc. United States. So a trademark is that nowadays they don't remember names, but they remember logos. They remember. How many of you know the logo of Facebook? F, right? See, this is what I'm telling you. Logo is very important again for a business. That is why trademark has great significance. License is given for trademark. Next is industrial designs. People who are here who manufacture things, right? Anything. There was a case between Samsung and Apple. The shape of the phone. Right? So Samsung had copied the shape of iPhone. So the design or the center button logo, that was the entire case about. So Apple had sued Samsung for copying it, right? Because they had the industrial design. So again, this becomes very important. Manufacturing copyrighting because it is important. Nobody should copy. The first person who have done it, so nobody should copy. That is why this again intellectual property right. Next is geographical indications. Tirupati Laddu, Banarasi Sari. Everybody knows, right? So again, Dindigul, correct. Then we have Tirunelveli Halwa. So all these things, if a particular, and another one is trade secrets. Anybody knows over here how to prepare a Coca-Cola or Pepsi? Can anybody make it? No. Yes. I'll give you a bottle, I'll give you money, you go and prepare a Pepsi and Coca-Cola and serve it. Can you do it? No. Because engineering students, budding researchers and innovators. So, very exclusive license to use that product in your name for the next 20 years. Simple. Exclusive license to use that product in your name for the next 20 years. Simple. What is Anybody has a doubt what is a patent? Ask now because it's going to be very important. You are going to make a product, you are going to make a process at the end of the third year. Okay, so whether the product or the process which you are making, can I get a patent for it? Whether already somebody else has got the patent for it, or would I be discouraged from doing it in India? Can I enjoy for now next 20 years for the hard work I have put in? That is what we are going to deal today. Okay, so it is not like you make any product, any process, and sir will give you marks and you can get a patent. No, sir will give you marks, but the patent office will not give you patent license for it. For that, you need to have certain conditions for a patent to qualify and get a license. So those conditions I will tell you today. Little technical I know, but I am sure that you will be able to understand. Ask me questions because nobody is going to teach you all these things for free. I want you to learn. Only if you go to an advocate, if you give them 50,000, 1 lakh, they will tell you all those things. But I want you to learn now. I want you to learn and tell your juniors also that we have learned about this, so be careful when you come into the first year. So I would also request the professors over here to take and also enlighten the forthcoming generation. So there are, in India, there is something called as Indian Patent Act 1970. And this is what I gave sir yesterday to circulate to all of you. Because whatever we do, circling the patents is all about this act. Nobody can act, no government, no authority, no patent officer can go beyond this act. It will be very difficult for you to understand the patent act. It will be all Greek and Latin. But whenever in future also if you are going to any advocate, he is going to look into this only. So I have given it to you. Be aware that this is the act under which the entire patent process is being regulated and referred to time and again, right? So in India, for a patent to be given a license, 3 steps are important. 3 essential steps. Only these 3 steps are there. Your product or process, for which the sir is giving you mark, can be patented. And without which no one will give you a patent. It's just a waste of time, it's just academic, and you will get a mark, you will get a degree, and you will go off. You will not get a patent for it. So be careful. The novelty of new invention. Whatever product it has to be novel. For example, if it's a kind of a scientific principle or a new, for example, it could be robotic, it could be medicine. So the person already a doctor or a scientist should not be aware of what you are producing. If I get a hint, if you show me something, it should be new to me. And the field, the person who's there in the field, it should be new to him and it should be novel. And it should be improvement to whatever is great. For example, there is a famous Gillette razor, you know all about Gillette razor shape that is the instrument, right? Gillette itself has around 1500 patents for the so every time they apply for a patent, they think some new innovation, some new improvement over that. So that is the novelty what I know. It has to be an improvement over what is already known in the market or in the industry. So for example, if your senior is doing something, if you can improve that, which is not there in the market, it can be considered to be novel, it can be a new innovation, and it can be granted patents, and the customer will be satisfied.
Focus.
Anybody has a doubt, you can stop me and okay. So novel, the first condition. If it's not novel, and all these conditions are not all, it's and. All the 3 conditions have to be satisfied or give you a patent. One will not get a patent. Second is an inventive step. Your patent is innovative. Right? You just nobody has done this in market. It's fantastic. Nobody knows about it. No student knows. No professor knows. No scientist knows. But whether it is easily guessable by a person who is skilled in the art. Right? If I go to show this particular product to Jawahar sir, whether he is able to guess it, hey, no, this is what you are trying to do. And I know about this. This is all. It should not be reverse engineerable. You know what is reverse engineering? I should not be able to reverse engineer and identify what product you are trying to give it to me. It should be an inventive step. Nobody should. And second important thing is like patents can be applied in different countries. It is not like if you apply it in India, you will get patented for the entire world. That is not the case. Apart from that, it should also be not known to other countries. If it is there in the public, you will not get patent, right? So it has to be novel, and it should not be known to people who are still in the art. It should not be known to anywhere in the world. If it is open in the public, it will not get patent. Sorry, sir. You can get patent.
இந்த பொண்ணு தலையை மண்டையை சொல்கிறேன் பேசுகிற மாதிரி இல்லை
You need to see whether your patent is available elsewhere. If it is not available in India, you can get it in
Kavya.
India, but not in other countries.
Hey you, hey girl.
No, there are certain restrictions I will tell you. I
You
will
want
not
to
process
fuck,
and dealing with that also. I tell you what are the restrictions. Right? So these two conditions you have satisfied. Now the third condition is capable of industrial application. Product panito, we have done the product. We have got it's novel. Nobody is using it anywhere in the world, but nobody can use it. It cannot be commercialized. It can only be kept in Savita Engineering College's medical library. It cannot be used. Such a kind of patent will no one will give you a patent for that. It has to be industrially applicable. It has to be used in the industry. If there is a patent, if I sell it, I should get some money, some revenue. Right? This is why you are here today. This is why you attend the college. That you should be so skilled that at the end of the day you make something, you innovate something so that you can get patent, that you can sell it out for money. So it has to be industrially capable of application. So this is the third essential ingredient for a patent. So keep in mind, even the professors, whenever there is a product or a process coming from a student, please see whether all these steps are being adhered to by the student, because their energy, your resource should not go waste, right? So these three are very important. Now next is, in India, they do not say for what I can give you patent. But in India, as per Patent Act, they say for what I cannot give you patent. They are very clear, right? So this is very technical, but I will just run through. I am not going to go deep into it. The only thing, keep those three ingredients in mind, you can get it, right? But specifically, our parliament says all these things cannot be patented. I just run through. It is very technical, so I am not going to disturb you with this. The first is a frivolous invention. What is a frivolous invention? You have copied somebody else's, or it is against the moral right, against morality, against public order. So if you do such a product invention or a process invention, they will not give you a patent. Second, a scientific theory of formulation. There is just a scientific theory, right? You have just made a theory which is already known to the public, for which no government will grant you patent. Or mere discovery of a new form, something called as paracetamol. You make Z as A and A as B, and you make a formula and you say that this is a new form of paracetamol, please grant me patent. No one will give you. It is already known that paracetamol is used to reduce temperature, or we use it as a medicine for so for which no one is going to give you. It has to be novel, innovative, inventive, and capable of industrial application. So they say that you cannot give you a patent for that. And again, next is a method of agriculture or architecture. I have made a new method of producing paddy, producing rice. So they say that you cannot get patent for a new method of agriculture and horticulture. Again, the other thing is a new process or a new medicine of treating human beings. As I said, again they are continuing. Okay, the next is plants and animals. Okay, like plants, animals, bacteria, microorganisms. All these things cannot be given patent for. All these things are known. All these things are natural. You say that no, I crossbreeded two animals, crossbreeded two plants. So there is a process through which I have done. Please grant me patent for the process. Nothing doing. The Act says you will not be given patent for it, because that's a natural process. That is not your application. That is a God-given process. That's a natural process. Why should a government give you patent for something that's natural? Nothing doing. Next is a mathematical or business method of a computer program. If you are a coder, if you code something, so coding or a business formula or a mathematical abstract, a theory cannot be patented. It will not come under the purview of patent. Right? Computer program can be copyrighted, but it cannot be patented. So it comes with other forms of patent. Next is a literary, dramatical, musical, artistic work. All this again comes under the Copyright Act, but it cannot be given patent. So Darya, what they do is, sir, I have an idea, give me a patent. Sir, I have written a book, give me a patent. So interchangeably, we instead of IPRs, instead of trademark, copyright, and other forms, we use the term patent. Patent is very famous. The term patent is very famous. For every IPR, we say patent, but we don't know what is patent, what is the difference between the other forms and the patent. So it is very important you should know, like what is the difference between the other forms of IPR. As I said again, the method of playing game, a different or you do something, you make some new rule, and you cannot say that this is the method of doing this something which is very new. Again, for that, no, this will be given for you. Or integrated circuits. Again, this integrated circuits acts under which you get a copyright. But for integrated circuits, if you are going to make or a process during the course of time for which no patent will be given to you. And something which is traditional knowledge. If you say that you have something called as Ayurvedic, Unani, all traditional methods of curing a disease in India. So all those medicines, all those things cannot be patented, but for that you can get a license under the other forms, right? So is this clear to you? See, all these things you can always get it done through a consultant after the end of third year. I'm just telling you, I'm just informing you that these are the restrictions placed on a product or a process. And you just need to know that in the Act, under Section 3 of the Act, these are the restrictions. Just remember, under Section 3 of the Act, which I have circulated, there are certain restrictions, and if you fall into the Section 3, you will not be given patent. You just need to know this, right? So now the next is, there are certain very interesting and very famous patents in India for which patent was granted. One is called as HD phonodoc. This HD phonodoc invention was actually patent given to Mr. Arvind Tyagarajan. It's actually a brain-basing device which actually detects a murmur for 10 seconds. 10 seconds will detect whether there is a murmur or a heartbeat. So they will detect your heartbeat in 10 seconds. And it is very important that in medical world, see whether there is any heart attack or something. So this device was very well recognized in medical
Sister,
The second very interesting
YouTube live.
patent form which I would like to tell you is about the breathing sensor apparatus. This was invented by
You are saying say hi.
And this is a device
Say hi.
which actually helps all the disabled people to do everything normally. So this was a device
running.
innovated in such a way that if you give it to a person who is disabled, who is not is blind, who is differently able, by using this, they can actually act as a normal student as a normal employee. So this was again well rewarded and patent was given and it's still in order. The third one is a washing system with high pressure for cleaning tubes of recovery steam generator. This was invented by Bharat Heavy Electrical Limited Company. A patent was given to the company in which, the invention relates to a system to remove the ashes in the spiral fine tubes of a heat generator. This was again well recognized in industries. I don't know who are industry based over here. So people who are from the industry related, they say that this was a very difficult thing, and by this invention, it was very useful for the industries and the was able to save lot and lot of money. So I would like to give you there is one particular case law which I would like to discuss. In every law college, in every law IT student knows about it. So there was one scientist known as Mr. Chakrabarti. So this Mr. Chakrabarti invented something called as a form of bacteria which would actually eat away oil spill. For example, oil coating or there is oil spillage in water or sea or on roads. So this particular bacteria, it was discovered by Mr. Chakrabarti, and if you put that bacteria on the road, it would eat away the oil. You will not even know there was an oil spillage on the road or on the water, and popping the derivative. So this was bacteria and he applied for a patent. So as I said in my previous slide, no new living form can be given a patent. No plants, no naturally occurring organism can be given a patent. So Mr. Chakrabarti applies for a patent. The patent office, this is actually a United States case, very famous case. The United States Patent Office, they say that this is a living form of organism. I cannot give you what is your innovation. I will not give you a patent, it was denied. So Mr. Chakraborty appealed.
அப்புறம் கமெண்ட் பண்ணு
In appeal, the circuit court says that this is not a naturally occurring microorganism. Its DNA was altered. It is not naturally occurring. Naturally, you cannot find this particular bioorganism. It is an innovation of Mr. Chakraborty that he has altered the RNA, the DNA. I am not a science graduate student. So hence, this particular bacteria is not a living organism, but it is a creation of Mr. Chakraborty. Hence, it can be patented. He was given a patent. Then again, the patent office again went for a second appeal. This is what happens everywhere: appeal. So in second appeal, again the appeal court says that yes, it was affirmed that this has been a creation. The person has put his hard work. This is not a natural organism. The DNA, RNA was altered. This is the novel, inventive step. This was never known by any of the scientists, and it was capable of industrial application. If you sell this license to any company which is working in the ship or marine industry, they will give you crores and crores of rupees. This was the industrial application, right? So Mr. Chakraborty was granted a patent, and this case is very famous, known as Diamond vs. Chakraborty. You can Google it whenever you are free afterwards. So this is a prime example, of the three essential ingredients which your invention or this process needs to have. So tomorrow one of you can be this scientist, Mr. Chakraborty. So be careful about the three ingredients. So there is something called as compulsory licensing. You know that during the novel coronavirus, many foreign companies were granted license for producing vaccines. Okay, so if they were granted patent, so are we in a position to take a vaccination by giving lakhs and lakhs of rupees? Are we in a position today to give lakhs and lakhs of rupees for a virus which is spreading?
No.
It is not possible, right? So compulsory licensing is something, even though a patent is granted to one Mr. X, if it is granted to one of you, okay, but you cannot say that it has to be exclusive. A patent, though it is given for 50 years, not always it's exclusive. The government, for certain reasons which I tell you now, can grant a patent during the lifetime, during this 20-year period, to someone else also. But there are certain conditions. If that condition is satisfied, a compulsory licensing can be given to a third party for producing, manufacturing and selling the same product. This is one exception to the patent. You cannot say tomorrow you should not fight that I have told you only if there are 3 ingredients I have got patent, nobody else can use. No. There are certain conditions under the Patent Act itself which says that compulsorily another person can also be given a license. That is called as compulsory license. I will give you an example for that. First one, Bayer versus NATCO. So this was the first case of compulsory licensing in India. India's first 2012, India's company called as NATCO Pharma had applied for compulsory licensing of a cancer drug. There was a cancer drug which costed in lakhs. Okay, in 2012. Now there are a lot of other medicines also, but in 2012 there was an American company called as Bayer, which has been given a kind of a patent for a cancer reducing drug. So NATCO Pharma said that in India it is very costly, nobody will be able to use it, and also it is not in India. In India that particular drug was not patented, so give me a compulsory licensing that applied to the government. So NATCO, see, I have already brought it that only 2% of cancer population had easy access to the drug, and the drug was being sold by Bayer at the exorbitant price of one capsule was 2,80,000 rupees. If you convert it into Indian rupee, so that is why NATCO had applied for a compulsory licensing that even though patent has been granted to Mr. Biopharma, US company, it has to be given to Indian because lots and lots of people are dying in cancer. So this is what they said. And they promised that they will sell the same drug, same formula for rupees 8,880 per medicine. So where is 2,80,000, where is rupees 8,000? So for public demand, a product which has been patented can also be compulsory licensed to anybody else if the government wants for the following reasons. Okay. it is not essential. I feel it's too technical for you. Okay, so just understand whatever license you are getting, it is not that nobody else can use. It can be given by the government under the concept of compulsory licensing. The first case for that was Fire versus NATCO. So the next comes very important for you. What is the process filing? People spend lakhs and lakhs of rupees in filing a patent in India. So being a second year and also a few third year students over here, process filing becomes very important. There is something called as specification and claim. Whenever you come, you say that I want to apply a patent for this product or this process. If you come to me, I would say there are two portions to it. You need to understand there is something called a specification. Specification is nothing but like the technical I know, but please bear with me for next 10 minutes and that. In specification, you just say what is your invention, what do you want to make or what do you want to manufacture. Okay, specification is the entire invention you have to describe. But a claim is something for which you want a patent. For example, if there is a pen, if there is a pen, and if you want to say that I want to get a patent for this pen, you don't get a patent for the pen. But you only get a patent for something called as claim. As I said, specification is the entire pen. You describe this is the pen. This is what I want to invent. You tell about the entire pen. But you will get patent only for the claim portion. Maybe Hero pen. Everybody knows Hero pen over here. They have got a patent for the nib. How many people know about the Hero pen's nib? It is very unique. The structure is unique. So Hero pen had a patent not for the pen. Everybody knows a pen. Nobody knows it. Everybody knows a pen, right? This is the right pen. So a pen in Hero pen had obtained a patent for the nib. So it is in this example, a nib is the claim. So we would say in an invention, the nib is new, the nib is novel, and it is the nib for which we are applying for patent and not the entire pen. The entire pen you can bring it in the specification. But the claim is here only for the nib. So specification and claim is important. That is what we draft. So whenever you are also inventing something or producing, make sure you know about what you need to specify and what you need to claim for as a patent, right? And second is something very important, provisional specification. There are certain third year students over here. They have started 10% work is over, 20% work is over. But as you know, in India, the person who first applies and gets a patent, this is his. Okay, the patent will be given only to that particular product. So there is something called as provisional specification. You need not give them the entire thing, right? You just say that no, this is what I'm planning, this is what is my tentative invention which I'm going to make, and you can apply immediately. Third year students can also apply. If they have just 20% or 30% of work, they can apply for it. This is called as provisional specification. You need not give them the entire claim specification. You can just immediately apply as a provisional. You have something called as provisional certificate, right? After graduation they give you. Similarly, you apply stating that within 12 months, I will give you the entire specification and apply. I will apply for the entire patent. But the person who has applied for a provisional specification, even though somebody in future is applying for the same thing, the person who has applied for a provision, he will be given a priority because he has applied as a provisional specification. So in order to somebody else not taking up your right, you can apply as a provisional specification and keep it. So this is one particular idea or tip I would like to give you. The moment you are ready with 20% of your invention in third year, you can apply for a provisional specification, we will apply it for you. And again, within 12 months, you can get the entire patent. So this is something which was very technical. And first is the application. We will find the process, pay, claim, specification. And it will be examined by the patent office and they will give you an objection. Like, it is not innovative, it is not capable of industry, already it is known in public. They will give you some kind of objections. So you will have to give the reply to the patent office. Something called an offer action response. You will have to go argue before them that why this is why all the three ingredients are there, why you are not giving me patent. You have to argue, and at the end of the day, you will be granted a patent for 20 years. So, how many, if you are being given a patent, why do you need to get a patent?
To protect
what are the benefits of patent?
To protect the product.
Protect the product, one thing. What else?
Idea should not be copied.
Good enough. Protect the product. Idea should not be copied. What are the other benefits of patent? Do we really need to get a patent? I have done a product, I have done a process, I have got a mark, I have got a degree, I am working in IT company. This is enough. This is what you want to do. Most of the engineering graduates are doing this today. Nobody is very R&D. Okay, I would say I have jotted down a few particular benefits as per my knowledge. Ensure complete protection against infringement. If you have a patent and if somebody is copying, you come to me, I will get you the remedy. I can file a case against him, I can get you lakhs and lakhs of rupees as compensation. Don't worry. Second is, it's tradable. Tomorrow if you have a patent, if you are really in dire need of money, you can assign this to any company. You see many people say that I invented a product, Anand Mahindra came to me, I sold, I lost crores of rupees I have got and I have now invested in my family business. So what is that? You got a patent for it, Anand Mahindra liked the idea, got the patent, he took it, you assigned it, you got 50 crores and you are enjoying now. I was a student of Sangeeta, you can say that. So again, it is patent invention is tradable, you can sell it to people for money. Again, it is access to early filing entry, So these are a few things it limits the competition, it generates income, it improves the market mix and improves innovation. If Mr. Sandhu would have restricted with one filing, you wouldn't have got 1,140. So, okay, I've got one patent, I've sold it for 50 crores, let me do another product. So 50 crores.
I keep working, yes.
Hey, wait.
What I wanted to speak, I want to speak a lot of things, but I feel you're not able to understand. So I am restricting myself. So once again, I am Yusuf. Thank you for listening to me. Other than notes. At least you understood what is patent. Everyone has a phone.
எப்படி சப்மிட் பண்ணுறது? அவுட் சப்மிட்
phone number है, phone number है.
7 8 சார்
Thank you very much once again.
எப்படி சப்மிட் பண்ணணும்? சப்மிட் எப்படி புரியல சார். சப்மிட் பண்ணுறதா?
டைம் ஆயிடுச்சு, கிளம்பு.
வந்து இன்ட்டா
That's all, sir.
Or you want to? Yes, stop. Okay, good.
அவனை வரல.